Good morning, everybody. In looking at the article by Steve Drizzen and Richard Leo, False Confessions in the Post-DNA World, we were, of course, dealing with an article that was published back in 2004. Obviously, the joint author of that article, Richard Leo, I've managed to find a much more recent article by him. This is from the University of San Francisco School of Law. It's a research paper, 2016-15. I don't quite know why it goes backwards, but anyway. It's entitled False Confessions in the 21st Century by Richard A. Leo and Brian L. Cuttler. And of course, I'll leave the link below for you to have a look through. But in asking some of the questions that I was asking last night, maybe this article will shed some light. I think it does. So, introduction. This special issue of The Champion is dedicated to the Miranda Decision, one of the most well-known and controversial US Supreme Court rulings in American history. The Miranda warning is so well known that even many Americans can recite a credible version of it, having heard it in countless crime movies and television episodes. But while the warning is part of our collective consciousness, Miranda has done little to reduce the risk of wrongful conviction resulting from false confessions. The overwhelming majority of suspects, between 70 to 98%, after being informed of their Miranda rights, waive them. Suspects give about as much attention to Miranda warnings as free Wi-Fi seekers give to click-through agreements to access the internet. Guilty of that one, I must admit. But once a suspect has waived his rights, police have free rein to conduct accusatory interrogations where they presume guilt and may deceive the suspect about the purpose of the interrogation, the evidence against him, and the consequences for both confessing and maintaining innocence. They aim to co-author a confession narrative. Although the Miranda decision changed police behaviour insofar as they routinely provide at least a nominal Miranda warning to suspects, police in the decades following Miranda strategically adapted their warning practices so that they do not inhibit self-incrimination by suspects. Police have devised strategies to avoid, circumvent, nullify, or simply violate Miranda warnings in ways that result in legally acceptable waivers of suspects' rights. Indeed, police have turned Miranda into a tool to solve cases through eliciting confessions. The police dictate when and how Miranda warnings are given and waivers are obtained, and control the control the construction of case facts around Miranda disputes. Whereas courts used to focus on the voluntariness of confessions, they now often focus on the voluntariness of the Miranda waiver. And once they conclude that the waiver is voluntary, the confession typically goes to the jury. In sum, the Miranda decision has, at best, had little or no impact on the risks of false confession and wrongful conviction. At worst, the influence of police on Miranda procedures and subsequent litigation has actually made things worse for defendants. I'm liking this guy already. False confession and wrongful conviction. The study of wrongful convictions has a long history in the US. In 1932, Edwin Borchardt was the first to publish a set of case studies of wrongful convictions and identify their causes. About every 10 years following the publication of Borchards's book, a new group of authors published a new set of case studies and courses. The advent of DNA technology in the 1980s and its application to criminal cases fueled interest in the problem of wrongful conviction. A recurring theme has been the set of errors that caused or at least contributed to wrongful convictions. False confessions figure prominently among them. For example, Hugo Badou and Michael Radlett identified 350 cases of wrongful conviction in capital cases between 1900 and 1987, and 49 of them could be attributed in whole or part to false confessions. Richard Leo and Richard Ovshi, 1998, identified an additional 60 cases of false confessions that led to wrongful conviction. In Rob Warden's 2003 sample of 42 wrongful convictions, 25 involved false confessions. And one that we know about, Stephen Drizzen and Richard Leo in 2004 identified and reviewed 125 cases of wrongful conviction resulting from false confession. By the end of 2015, the Innocence Project had tallied 336 DNA-based exonerations. 88 of the first 325 cases contained false admissions or confessions. The National Registry of Exonerations uncovered 1,721 wrongful convictions by the end of 2015. And 219 were innocent individuals who had falsely confessed. Thus, researchers have documented hundreds of cases of wrongful convictions in which false confessions were contributing factors. We should not be surprised that false confessions often become wrongful convictions. False confessions are the most incriminating form of false evidence that the government can muster against an innocent defendant. Confessions, even when they are false, appear authentic and self-corroborating and have been shown to bias the proceedings that follow. False confessions set in motion tunnel vision and confirmatory biases, which can corrupt other evidence such as eyewitness identifications and judgments of forensic scientists. With a confession in hand, police typically believe that the case has been solved and stop investigating other suspects. And prosecutors tend to be sceptical of allegations of false confessions and treat those who confess more harshly than those who don't. For example, by charging them with more and more serious offences, setting bail higher and taking a more punitive stand in plea bargaining. Defence attorneys are not immune to the persuasive power of false confessions. Suspects who confess are often believed by their own attorneys to be guilty. Isn't that so true? Len Kaczynski. Defence attorneys often pressure their clients who confessed to take plea bargains rather than risk harsh jury verdicts. When a case does go to jury, a confession carries a great deal of weight, typically resulting in conviction even when the confession is false. Confession evidence is perceived by the jury to be more potent than virtually any other form of evidence. Lay people are inherently skeptical about claims of false confessions and prone to errors in attributing casualty. To wit, when explaining a suspect's confession, they look for the internal reasons, such as the defendant's guilty conscience, rather than external reasons, a highly coercive interrogation that would lead even an innocent person to confess. Studies of juror decision-making reveal that jurors believe confessions and rely on them in their deliberations, even when the confessions were given by a suspect who was particularly vulnerable to social influence. The confessions were judged to be coerced and they were retracted. Even those who dismiss jury simulation studies cannot ignore that in the hundreds of wrongful convictions in which false confessions played a role, juries believed the false confessions and convicted based in part or in whole of them. In short, the suspect who falsely confesses is more likely to be incarcerated prior to trial, charged, overcharged, pressured to plead guilty and wrongly convicted. Next paragraph. Developments in the study of false confession. Scholarly and professional sources contribute to our knowledge of false confessions. Our understanding of the link between false confession and wrongful conviction has been developed based on compendiums of wrongful conviction cases published in books, ongoing data collection and analysis by the Innocence Project and the National Registry of Exonerations, and documentary research of proven false confession cases. And our knowledge of psychologically coercive interrogation techniques has benefited from 1. Research on false confessions, 2. Observational research of actual interrogations, 3. Surveys of police investigators and suspects, 4. Psychological experiments involving police, and 5. Experiments involving simulated interrogations, and 6. Study of commonly used police training manuals. Documentary research has also contributed to our understanding of how investigators can contaminate false confessions, and studies of jury and judge decision making, as well as serving as jurors, have enriched our understanding of the powerful influence of confessions on trial outcomes. The research literature on false confessions is substantial. A Google search for false confessions conducted at the end of 2015 produced more than 5,000 citations, nearly 1,500 since 2011. Research on interrogation and false confession regularly appears in peer-reviewed social science journals and chapters and books published by respected academic presses. Of course, end of 2015, Making a Murderer came out. Be interesting to see what these professors think of the effect of Making a Murderer has on the wrongful confessions. I certainly think that it's made quite a difference when you've got these Zicklander and Walensky, or whatever it was, the interrogation experts, changing their policy, using the Brendan confession as an example of what not to do. Anyway, let's crack on. And in the past decade, there have been several comprehensive reviews of research on false confessions. The maturity of the research literature has led to significant efforts to affect practice and public policy. One of the aforementioned reviews was a scientific review paper endorsed by the American Psychology Law Society Division of the American Psychological Association. The development of this paper followed a rigorous consultative and peer review process, and it is one of only 2 scientific review papers thus far produced by the association. The APA's Office of General Counsel is responsible for submitting amicus briefs on behalf of the association. To date, the APA has submitted 6 amicus briefs on false confession research. In 2014, the APA's Council of Representatives adopted a resolution on interrogation of criminal suspects that highlights the research on risk factors associated with false confessions and recommends various safeguards to reduce the risks. Understanding false confessions. Leo and Drizzen identified 3 categories of investigative error that led to the production of false confessions: misclassification errors, coercion errors, and contamination errors. A misclassification error occurs when the investigator erroneously concludes that an innocent person is guilty of the crime under investigation. Many factors can contribute to misclassification errors. One is that many investigators are not trained in effective methods of interrogation, and numerous others receive training that is misleading and increases the risk of misclassification errors. Specifically, trainers of what is known as the Reed technique teach investigators through manuals and workshops that they can become highly adept at distinguishing truth from lies. Following training, the investigator comes to believe that he should be able to determine whether a suspect is lying or telling the truth. The training describes the verbal and non-verbal cues associated with deception. But this training is highly misleading. Decades of social scientific research unequivocally demonstrates that the ability of people, including police investigators, to tell the truth from lies is, at best, only slightly better than chance. The verbal and non-verbal cues that trainees allege to be associated with lying are not reliably associated with deception. Research on investigators' abilities to distinguish between true and false confessions shows that they are no better at this than laypersons, but that investigators make decisions about the veracity of confessions with higher confidence than laypersons. Other factors contribute to misclassification error as well. The pressure to close cases, particularly high-profile ones such as murder, can lead investigators to interpret ambiguous information from a suspect in accordance with the investigator's preconceived notions about the suspect's culpability and to ignore disconfirming information. Investigators are human and rely on heuristics and biases in their decision-making, even more so under intensely adversarial conditions. They sometimes draw conclusions based on incomplete, unrepresentative, and ambiguous information. Once a misclassification has occurred and the investigator has deemed an innocent suspect to be guilty, the investigator's next step is to subject the suspect to a guilt presumptive interrogation. The goal is to produce a confession. The confession is particularly important when there is no other evidence against the suspect. Modern interrogation methods are designed to be psychologically manipulative and to influence the suspect's perception of his situation and his expectations for the future. They aim to move him from denial to admission. Leo and Drizzen defined psychological coercion in interrogations as the use of tactics that overbear the suspect's will, such as through promises or threats, or tactics that cumulatively cause the suspect to conclude that compliance with the interrogator's demand for a confession is his only viable option. Psychological coercion may include some combination of isolation, deprivation, and questioning that, through time or intensity, produce fatigue. But other tactics are more common in modern interrogation. Confident assertions by police of the suspect's guilt, confrontations by interrogations that employ real or fictitious evidence of the suspect's guilt, feigned desires by police to help the suspect, the offering by interrogators of explanations, legal justifications, and excuses for committing the crime that appear to minimize the suspect's culpability, and promises and threats whether implicit or explicit. These and other tactics are designed to lead the suspect to conclude that his guilt will be established beyond any reasonable doubt, that he will have no chance of convincing anyone of his innocence, that maintaining his innocence will only worsen his situation, and that by confessing he will be able to improve it. The irony of psychologically and coercive interrogation is that it leads the suspect to conclude that an otherwise irrational decision to falsely confess, under these circumstances, has become a rational one. The investigator's next task after obtaining an admission of guilt is to turn it into a full-fledged and compelling post-admission narrative that will help build the case against the suspect and win a conviction. The investigator understands the importance of the narrative and helps the suspect construct a convincing plotline, including motives, remorse, and crime details that can be corroborated and that give the appearance that the suspect possesses incriminating knowledge and the feel of truth, or never come across this word before, verisimilitude. You're trying to go that one when you read the document, see what you make of it. But it did remind me of Veritaserum in the Harry Potter movies. Anyway, investigators may suggest details to the suspect verbally or through crime scene photos. They may pressure or even coerce the suspect into adopting their storyline and details, and may rehearse the storyline so that the suspect can tell it without hesitation or mistake. As Offshee and Leo first illustrated, investigators contaminate most suspects, i.e. leak or disclose non-public case facts to them, who then incorporate these details into their false confessions. More recently, in a study of the first 250 post-conviction DNA exonerations of innocent US prisoners, Garrett found that contamination was present in 95% of the false confession cases. In these cases, police wrote in their reports and subsequently testified under oath at pre-trial hearings and at trial that these defendants not only admitted to committing the crimes, but confessed to a number of specific non-public facts about how the crime occurred, supplying surprisingly rich, detailed and accurate information. Those facts included information that matched the crime scene evidence, scientific evidence, expert evidence, and accounts by the victims. In other words, 95% of those future DNA exonerees gave confessions that were complete with incriminating or inside knowledge of the crime supplied by their interrogators. Yet all of these individuals were factually innocent. None of them had even been present at this crime scene or knew any of the non-public details memorialized in their confessions and recounted at great length in their trials. Police investigators disclosed non-public crime details to the exonerees during the unrecorded interrogations by telling them how the crime happened and feeding them crime facts. They sometimes showed the defendants police reports, co-defendant statements and crime photographs, and even took some of them to the crime scene. Yet the same investigators emphatically represented in their reports and sworn pre-trial and trial testimony that the non-public crime facts in the defendants' confessions had been provided by the defendants themselves, not the investigators, that they had assiduously avoided contaminating the confessions by not asking leading questions, but rather allowing the suspects to volunteer crucial facts. In a follow-up study of more recent false confession cases, where the defendants were later exonerated by DNA, Garrett found that 21 of 23 of the confessions were contaminated. We'll hold it there. We're halfway through. Next section, going to be very interesting. Strategies for litigating false confession cases. As I say, I'll leave the link in the description below, and you can have a read through and see what you make of that word that I found pretty unpronounceable. Anyway, catch you again soon. Bye for now.